Good afternoon, everyone, and welcome to our now routine conversations about privacy. I'm joined with Justin and Tony Pillay, and the two of us have a great guest on today, Alastair Mactaggart, who is behind all the exciting developments in California. A few years ago, we had the California Consumer Privacy Act. And this year, there's a referendum on the ballot in California known as the CPRA that will make some very impactful amendments to the now active CCPA. So there's a lot to talk about, and let's get started. Welcome, and thanks so much for joining us.
Thanks for having me.
Alastair, thanks for joining today. And for our viewers today, I'd say Dan and I have been really blown away by the reaction we're getting to our privacy conversation series. Our series around the Schrems 2 decision, we had a phenomenal conversation with just amazing women leaders in our profession, and we're getting 5, 7, 10,000 folks joining us for these sessions. And I think it shows just what a commitment there is and how much interest it is in the area. So we're really delighted to have everybody today. And Alastair, great to chat again. We almost always start the conversation by just starting with, assume that a lot of the folks here know you. And obviously the CCPA has effectuated a huge change on the privacy front. But before we dive into Prop 24 and the CPRA, maybe you could just give a little bit of an introduction to our viewers today and talk a little bit about, how you got into this. And, you have definitely put money where your mouth is on this issue. So how did you get into this, and what motivated you on CCPA 1.0? And then we can dive into the same thing on now CPRA.
Well, thank you. I'm Alastair. I'm a husband. I'm a dad. I have 3 little kids. I'm a business real estate guy out here in California. And, I think a lot of people have heard me tell the story that it was a chance encounter with a Google engineer that led me down into thinking about this and getting into it. And honestly, there's so much luck involved along the way. When I started looking into this, I kept on thinking I would find the reason why this was a bad idea. So it was obvious to me why the legislature hadn't acted, because the power of business, in Sacramento is extraordinary, and these are very big businesses. But I kept on thinking, well, there must be a reason why no one has done this. And then one thing, you just keep on doing some more research and turning over rocks, and you keep on waiting for that reason you can't do it. But eventually I put a ballot measure together in 2017, put it on the ballot in 2018. And then in terms of, again, the luck part, I didn't even know when I started that the legislature could really intervene and suggest that there would be a new deal. In fact, that was actually a brand new law, I think in 2014, that the person I ended up doing this deal with, Senator Hertzberg, he was the one who put that provision in the law in California that a person like me who had qualified a ballot measure had a certain window to negotiate with the legislature. So that's what happened. And in June 2 years ago, in 2018, we passed, well, not we, they did, the legislature passed the California Consumer Privacy Act unanimously out of both houses, like with 3 hours to go before my deadline to decide to leave it on the ballot or not. And it was signed into law by Governor Brown. So that's kind of how that happened.
Yeah, that's great. By the way, Dan, I'm seeing some comments just to make sure they're saying there's no sound. I can hear you very, very clearly, Alastair. I don't know, can you all hear me?
Dan
may be muted.
I can't hear Dan now.
Okay, great. I've got more comments saying that there is sound. Dan, you're still on mute, just so you know. And let me just say, we've had just a great group of folks show up already. We do encourage our viewers, please post questions in the comments section, and we can get those in front of Alastair as well. So, I think we talked about CCPA 1.0. Dan, do you want to take it from here on 2.0?
Yeah, and I'm curious what the goals are and the impetus for CCPA 2.0. The ink is barely dry on CCPA 1.0. The regulations have just come out, and now we're in round 2 already. And so I'm curious what prompted you to move forward at this time to make the changes that you're making.
It's a question I get a lot, and I have sort of three real answers to that question. And the first is really what happened last year in 2019. So talk about the ink being barely dry. January of 2019, the ink is barely dry in CCPA. I'm like the newbie showing up in Sacramento trying to hear there's some amendments coming, and what I actually saw was business mounting a full-fledged attack on CCPA just to kind of dismantle it. So there was a bill to remove all insurance products coverage companies from the law. There was a move to remove all vehicle data from the law. By the way, cars are computers on wheels. There was a move to destroy, to remove all behavioral advertising. So that would have been the tracking you from website to website, from device to device, which is kind of the point of a privacy law. And that was sort of breathtaking. I thought, oh my goodness, this is eye-opening. Now, luckily, and by the way, these were not bills that just kind of random people. That insurance one, to remove all insurance from the scope of this, that got out of the Assembly unanimously. But we had a couple of key senators, among them the co-author of CCPA, Senator Hertzberg. So that's one, was to protect the law. And the way this works is the initiative law is separate from, in California, is separate from legislative law. The legislature can't change initiatives unless the initiative gives the power to the legislature to amend it. Ours, if it passes, says, hey, you, the legislature, can make any change you want with a simple majority, but you can't do anything that harms consumer privacy. So reason number one is it's a floor under privacy if this passes. It protects privacy for Californians. Number two, if we're going to do that, we might as well get all those rights that the Europeans have that we don't have. So if we're right now, I kind of say that we're the second world of privacy. If the dictatorships are the third world of privacy, and if Europe's the first world, this would make California on a par with Europe. That's the second reason. And then the third one is enforcement. The enforcement right now is in the hands of the Attorney General. He's on record as saying he doesn't have the resources. He has bigger fish to fry. He's a cop, not a regulator. This would create a data protection authority. This would create much more robust enforcement with guaranteed funding. So those three reasons, again, are protect privacy in California, give us the rights that we deserve, that are enjoyed by Europeans, and then better enforcement.
How much funding can you get for this? Because I find the California system very interesting. That you can get a ballot initiative and actually fund an enforcement agency of sorts, create one, and can you dictate how big it is and how much funding it gets out of the state budget?
Well, I can't. The voters can if
the voters.
If they do this.
How big can we make it?
In the proposition, we have $10 million indexed annually. And right now, this year, the Attorney General was allocated $4.6 million, and with it hired 23 people. Extrapolate that, 10 million is about 50 people. The FTC has 40 people for the entire country. So this would become at a stroke sort of the most powerful privacy agency in the country. Now, people have said, oh, how can, that's a tiny drop in the bucket compared to these trillion-dollar companies. Well, nothing stops the legislature from allocating additional funds. And then what people should know is the way the funding works is any excess funding goes back to the state. So you first cover your costs, then it goes back to the state if you get a big fine.
Yeah, so, and maybe I'll pick it up from there, Alastair. So, obviously it's a proposition and it's still on the ballot. So I don't know if you can talk a little bit about what you're seeing in terms of how it's doing or how the poll is going. But what would be one of the things that would be helpful is for us to go through, even at the high level, for folks joining today, what are the high level, kind of main changes? You covered a few of them, but high level main changes that you pay attention to. And then, just like everything, there are criticisms and folks that are opposing Prop 24 CPRA. And some of them are groups that you would think are associated with privacy protection and or advocates. So one of the things I thought we could do is, after we go through some of the main changes, actually talk about some of the criticisms that are out there and go back and forth on that a little bit. So, but why don't we start with, when you think about the major changes in the law, what should people know at the high level?
Sure. Well, I think one way to think about this is kind of what I was saying earlier. This really just harmonizes California law with the major features in European law. So what are some of those? We have purpose limitation, storage limitation. We have a chain of custody requirement, data minimization, a new right to correct. One of the ones that sort of resonates the most with consumers when we talk to them is this concept of a new category of sensitive personal information. And that is stuff that is, anybody would understand: your health, your religion, your biometrics, genetics, your sexual orientation, your race and ethnicity. And what we say is, look, that stuff is so sensitive that you should be able to have the right to tell a company not to use that information. One of them is like precise geolocation. So again, importing from the European idea, we draw a circle around you about 250 acres. And we say, okay, we understand that you might need to know where I live to advertise. So I'm a Los Angeles resident, but you actually don't need to know that I'm at the gym or at a fast food restaurant. And so I can kind of blur my location within that 250 acres. And when you talk to people about not being tracked right to where they stand, this really resonates with people. Profiling is another big one. The right to say, hey, are you using automated decision-making? I want to object to that. This is the creation of these profiles. Am I only seeing certain information because of my education, because of my gender, because of my race? And, is that why I'm only seeing these job opportunities? How would I even know? You don't have to worry. The discrimination laws are on the books. The question is, how do you understand whether or not you're being discriminated against? And this is what this opens this door. Again, that's a European construct we import. And then in terms of the enforcement, a lot of requiring the high risk data processors to have the risk assessments, to have the cybersecurity audits, to create a chief auditor that can go around and make sure businesses are complying. So these are some of the main features in the law.
So how
By the
would
way, I'm really struck, by the way, Alastair, having met you years ago and then on watching you early years ago on CCPA, how much even like we're talking more about a convergence with Europe. You've referred to Europe a couple of different times. By the way, it's a convergence. It's not identical, right? There's some pretty specific places where you've clearly, and the folks behind it have made a decision to not adopt just Europe wholesale, right? One option could have been, hey, I'm just going to take GDPR and that's Prop 24. So there's both a convergence theme you're bringing up. Hey, we looked at that, we're informed by that, and then a divergence, or like we've chosen to go a different way. How do we think about that? How do we think about it in the community? Why are you mentioning, for example, so much around the convergence point? Like, why is that important in terms of how you thought about it? And where are you thinking about it principles-wise on divergence? Like, where do you think about it differently?
Well, I think convergence, we're trying to, I guess, take the best. There's a sort of approach of trying to take the best parts of the European law, import those. Some obviously run into constitutional issues here. I know there's a lot of Europeans, experts get upset when the right to be forgotten is characterized as a infringement on freedom of speech. That notwithstanding, there are sort of issues here that we have to take into account. So one of the reasons, for example, we are opt-out, not opt-in, is because of IMS versus Sorrell, which, for your viewers who don't know, that's a Supreme Court case in 2011. And the notion that you're giving consumers the right to opt out, that's a different framework than requiring the businesses. And by giving consumers the right to opt out, that's more like a do not call framework, which also was a challenge to the Supreme Court, and they didn't hear it, where it's held to be a restriction on commercial speech as opposed to First Amendment rights of corporations. So there are some divergences to deal with our different legal systems. And then there are some areas where I think there's a philosophical difference. We are more, I think, inclined to, I would say, take a slightly more American approach with respect to choice, to allowing consumers to in many respects, interact with a business, and in some cases maybe get a discount for doing so. And so we don't forbid a whole bunch of things in maybe the same way that the European approach does. But I would say there's a lot more convergence than there is divergence, Justin.
So what would be your ultimate goal? So ultimately, let's say, a few years down the road, how would you measure the success here? Because obviously when you create laws, it's very hard to predict exactly how they're going to work in practice, what they're going to achieve. Will people use them? Will people take advantage of their rights and exercise them? Will we see, like, how would you determine if the needle gets moved? Are there certain metrics that you have in mind to evaluate, are we done after CCPA 2.0, or, will there be 3.0 and 4.0 and more? So what are your long-term goals, and how will you evaluate, when they're achieved?
Well, so I think that, one of the things we all need to get kind of comfortable with is this: privacy isn't going away. And it is kind of a new thing in the sense that it's not new. The concept's obviously not new. And our framers essentially addressed it in the Fourth Amendment. But for most of human history, the technology wasn't there that really made it anything. You had to worry about it really with respect to governments, right? And even when the phone came in, it was sort of like, well, the phone company doesn't really have the capacity to monitor all the conversations, so it's again limited to government. But now this technology exists where we're all voluntarily disclosing most of who we are to a handful of companies daily. And again, I say this as a business person, and I'm a big fan of the internet. Obviously, the ability to have the world's knowledge at my fingertips is an extraordinary invention. And with that, also for these companies comes some responsibility, because if you think about the fact that now they know everything I've ever searched for, and every last thing I've typed into it, where I've gone, how long I've been there, who I've been near, with that knowledge comes power. And it's the power we all, it's talked a lot about. It's not my observation, but the power to push me in a direction, and I don't even know I'm being pushed in that, right? And what you didn't have before were the supercomputers that could use all this data. You didn't have the algorithms that could effectively learn. And it really is something out of science fiction, where it's not even the creators who understand. They just dump all the data and say, find the correlations. And then you have this unlimited sort of stream of data coming in now. So we're all monitored all the time. And no one I don't have to tell your audience, but if a little experiment by Facebook can change a voting pattern by hundreds of thousands and potentially millions, because they didn't show it to very many people, so it was 2010 or 2012. This is real power, this technology. So to get back to your question, this is a law, CCPA. Another new one is CPRA. I think after this, I don't foresee a need for me to sort of get involved in trying to change the framework, because I think this framework is robust. Because think about what we did. We set up a regulator governed by this sort of FTC-like commission, which is supposed to be independent. And so it's appointed by different people. So you don't have the vagaries of changing with the administration if a new AG is elected. We get guaranteed funding, and it's got rulemaking authority. And it can go in one direction, it can change. Well, I think that's the right framework that can adapt over time. But I think the notion that we're not going to have privacy in 50 or 75 years, this is much more, in my mind, I keep saying it's like antitrust, which when it first showed up was new. And 130 years later, we're still talking about where the line is between monopoly and what's good for consumers and what's good for society. That's privacy. All you privacy lawyers out there, you are in the right business, because for the rest of your careers, this is just going to be evolving, because it's really important. It's really important who has control in our society. So
do you see any, in terms of the future? I mean, one thing is, with with California and just with the polling on the initial polling on the CCPA referendum before, and now the polling on this one, very, very popular. And you could almost put anything on the ballot and on privacy, and it's likely to pass. So there's a, there is more that could be done in California. Do you have any thoughts on other states or at the federal level of a way to influence some change there? Obviously, we don't have a referendum process at the federal level, but are there thoughts or strategies that you have in mind that might, pursue that?
Well, Dan, one of the reasons I was excited about doing this now and was willing to sort of spend the money on it is it's my contention that if this passes in California, if it passes, by definition, it'll be millions and millions of people voting, because our electorate is, we have 21 million registered voters, right? So whatever the turnout's going to be, if it passes, it'll be a lot of people, which I think sends a message to the Democrats from California in the House. And we're 20% of, at this point, I don't know what happened after the election, right now we're 20% of the House Democratic Caucus. I think that means that we have a very high bar at that point in Congress for anything getting out, because there's a lot of talk of preemption, but hard to do that if you're going to gut California, I think, with people who represent a state that will just have voted on this. So I think that's a great message to our representatives in Congress. And again, it sometimes seems they can't agree what day it is there. So I'm not holding my breath that Congress is going to actually pass an omnibus, comprehensive, good privacy law. And as an American, if they do, great, wonderful. So that's one option. The other option is that the states act. And I think we've seen this, data breach is a good example where people kind of understand it makes sense. California passed the law. And eventually the 50th state, I think it was Alabama, passed the law. And I think it was like 12 years later, we got there, Congress didn't act. And so I think that's what's going to happen here. If California passes this law in a way that business kind of understands, okay, we're not going to weaken it in California, so that's a baseline. I think you'll see everybody kind of, I actually think the business, and remember, CCPA, certain businesses, Microsoft, Apple, both extended CCPA rights to the entire country. Very difficult when you think about it for a consumer company to say, hey, I'm going to treat my California customers differently and give them these great, consumer rights, but I'm not going to do that for you in Texas or California. So I think if this passes, you're going to have a push on the business front to extend these rights to America. You're going to have other states that are going to, feel the pressure to adopt something like this. And Congress will feel the pressure. Whatever happens, I think the American consumer will win. And so I think it's really important to do this now, to draw a line in the sand and say, for the country, hey, the biggest state in the country is going to take this step. Everybody else needs to kind of pay attention.
Yeah, and so I want to pick that up in a couple of different ways, Alastair. First, we've talked a lot, and I think it is really important to highlight, this is a consumer-facing law. So what this matters to people really is the critical driving factor. Part of this also is, okay, let's assume it goes into effect. What is the effect for business? Like, how do companies start thinking about this? My look at the polls is the same as Dan, which is, I don't want to jinx anything, but it looks like you have a lot of support in California behind this. In terms of, cross your fingers. So let's not say any more about that for now. But if you're a business and you're thinking about this, first of all, look, both Dan and I are in the industry, and a lot of our viewers have been working under CCPA. So you have a lot of companies that have had to put the basic infrastructure in place to manage under CCPA 1.0. When I was looking at the law, there are some very important new rights for consumers that I think have a material change for consumers. From the business side of things, this is the first time in the US, assuming it passes, that you have regulatory requirements with an actual audit and enforcement agency for companies. And it's the first time that you have a GDPR requirement for assessments and documentation, right? So those companies that applied creating privacy impact assessments and creating a record and being ready for an audit and being prepared for that. That's a big change just in a very practical way for companies who did not do GDPR. Now you have your first requirement for assessments and documentation and compliance. And, you've seen that's actually an element of the Washington law that's proposed, but this is the first one that will really happen in the US. So that's one big change. Are there other significant changes that you have in mind? You're obviously a business person. Like, where do you see the impact if you've already been sort of thinking about CCPA 1.0? Like, how do companies think about that? And then when we're done with that, I know that we keep these sessions relatively short. I knew we'd have way too much information. But part of the Prop 24 process, as I mentioned when we started, and maybe we can come to this after that first question, like, how do business really think about this? What is this going to change for them? I do think it's probably worth us talking about. There's criticism for Prop 24 tied in many ways to what you said at the outset, which is it's not trying to be absolutist. It's trying to make some pretty significant incremental changes, right? And there are different criticisms of that. But maybe we could come back to that in a minute with some specific items that have come up. But from your perspective, what are the major things companies, businesses, folks who are trying to help companies get this right? What's going to be the burden on them? How do they think about it once that goes into effect?
Well, look, I think that a lot of this is sort of a step function, kind of one-time change, right? You were used to a world of no regulation. You used to be able to dump your paint in the river, and you could dump your paint thinner on the ground, and then Lake Erie catches fire, and people are like, okay, this is not a good idea. We need to have some environmental laws. And now no one would think of doing that. It's taken a while to get there. That's kind of where we are, really honestly. So I'm sympathetic to business in the sense that, okay, this is a change, but I'm not sympathetic in the sense that they should not think that there's a world where we're going back to, unlimited ability to kind of mine and collect and monetize people's information without their having any input into that. And so I think business should understand this doesn't go into effect until January 1st, 2023, if it passes. And I think also, look, it's good for business in the sense that, as I said earlier, by putting it in the hands of a professional DPA, you avoid, the swings where one attorney general is elected and goes this way, and then the next attorney general is elected and goes this way, and that could be bad for business. So I think business should expect that they have a 2-year window. The good news is the work that they've done on CCPA, this is accretive. So it's not like a CCPA gets thrown out. All that work on access and deletion is still necessary and is part of the new law. There's a new, obviously, category now of sensitive personal information, the ability to, I would have to stop businesses using that. And so, I think business, it is more regulation. I think it's thoughtful regulation. In many respects, I think we've improved the operations of the law. For example, we clarify that service providers don't have to respond to access and deletion requests. That's not in the CCPA. So there are things we did to improve the workability if they didn't harm consumer privacy, which there were a number of those examples.
Yeah, well, that really helps, and we'll come back to, I think, on a further session some more of this, Alastair. Let me bring up. Look, you've seen some of the advocacy groups. This, by the way, must have. I don't know if it was a blindside. You're out there. Your organization is for consumer privacy, and suddenly there's no it's not like there. By the way, it's not like there's an alternative proposal that is the A versus B. It's like pass this versus nothing that I've seen right now. And yet, even in that scenario, there's some pretty strong criticisms that have come up from advocacy groups you would normally associate with the consumer side of things, or like the privacy protection side of things. And that scenario is kind of interesting. So you could comment on that. But hey, were you surprised this stuff was coming up from without an alternative? And then I'll cue you up with one or two of these. There's a pretty strong criticism that somehow this CPRA either encodes or codifies or promotes more automated, more profiling or unfair automated decision making, or digital redlining, it's called, right? Like that's a thing that's been put out there. There are similar criticisms that somehow that the proposal is promoting a pay for privacy regime. Like those are two I see pretty often. So if you don't mind, like, hey, were you surprised that this came up this way? And how do you react to some of these points?
Yeah, I mean, surprise doesn't even begin to address how the advocates sent us a letter last fall when we were doing the drafting process. We made 27 of their 41 changes. One of their changes actually would have removed all essentially advertising. It said, they requested that we not use any personal information in advertising, which included the page you're on and your search history. So there goes the search model of putting up the advertisement by the search. So we made a bunch of their changes. They were good. Some of them were good changes. When I found out ACLU was opposing, I was just stunned. I think the answer to this is that there are a whole bunch of groups out there for whom the perfect is worth dying for. And if it doesn't do exactly what they want, they're going to oppose you. And it's sad, because I'm a big believer that, I'd rather get something done and move the ball forward. And again, our construct here is anything is open for amendment in the future as long as it doesn't harm consumer privacy. So if you don't think this goes far enough, you should come back to Sacramento next year, work to get this passed, come back to Sacramento and move it further. So on the redlining, it's preposterous, frankly. It's literally the opposite of what we do. We give consumers the new right to say, you can't use my race or my ethnicity. You can't use it. So if I'm getting a loan quote, you don't have to know what race I am. It gives you the right to stop being profiled. You have neither of those rights do you have under CCPA. And now you'd be able to say, wait, are you using automated decision making? And tell me about the algorithm and let me say no. I mean, it's literally the opposite of digital redlining. Then under the pay for privacy thing, which I would call preserve the free press, again, they're very disingenuous. That is current law. The way the initiative process works is we have to reenact current law with some changes. We didn't change that section. They're pretending that this is an invention that we have and that we're showing up and we're now going to make only rich people have privacy and poor people won't have privacy. The reality is, if you follow through their logic, A, it's existing law. B, their logic would now say that a newspaper site could not offer something where they show ads in response and let you the viewer, see it. So now what happens to that newspaper business? Are they going to have to charge everybody a subscription? And then are those people, so what happens to the free model? What happens to, I actually have Pandora and Spotify. I pay on one and I'm free on the other. I don't mind. I mean, I listen to some commercials, but that model would go away, where the business is allowed to show you ads in response for free access. So again, it's a sort of ivory tower criticism, which has been really disappointing. But one thing to remember, ACLU didn't support us in 2018. They did not support the CCPA. Now that it passed, and now they're out saying, oh, we must defend CCPA, but this new thing is wrong. I guarantee if this thing passes, they'll be like, hey, this new law is fabulous. Don't even touch it.
Yeah, I mean, look, I get the incremental approach. Dan, I don't know. Did you want to jump in before I follow up with one more?
Yeah, I guess one question I had was that, this goes to the CCPA and CPRA. A lot of it depends on, the individual exercising rights. And especially with big data and with so many companies that are using your data that people don't know about. What in these laws addresses that issue? What are consumers to do when they just don't know what's going on? If you know what's going on, then and you care about it, you can do something about it, and the law empowers you to do that. But what about when you don't know? Is there anything that can be done there, or is that something else to tackle at another point?
That is a great question, and that's why in CCPA and CPRA we have this construct, which actually they don't have in Europe. And this is go back to Justin's point about divergence, convergence. I think if it's up to the consumer, we're doomed, because the businesses are smart about making it difficult. And so both laws have this construct where you, the consumer, can essentially hire a third party to do it for you. Think of that third party as your browser, as your a global phone setting, and it will opt out for you. So all this distinction axiom on opt out, opt in, I think goes away, because I'm going to actually have a entity do it for me. My browser will do it for me. And I don't know if you followed, I think it was, the same week, is it last week, the global privacy control, the researcher from Wesleyan, Ashkan Sultani here in Oakland, who helped me on this law, have come up with this concept of a signal that you can, put in your browser, and some of the browser companies are accepting it. Some big news organizations are accepting it. That's going to be the future, where you don't have to think about it. The same way, none of us are virus experts. We all have an antivirus somewhere in our system. We've all been trained over the years. You better have one, otherwise bad things will happen. That's what's going to happen with privacy.
And so what would happen, I guess, one response that, companies might take is, well, we will find a way to entice people to opt in or will not opt out, essentially, to let us use their data. And then, you can, entice people with not that much. And so is there a danger that, ultimately, the consumers get, maybe a little bit more discounting or a little bit, better benefit, but ultimately, this goes to the monetization of privacy. Their privacy is bought at a slightly higher price.
So it's a great question. So a couple answers to that. One is, in the section that deals with this in the law, we have we try to put guardrails around this concept, and we say that exchange can happen, but it can't be usurious, coercive, unjust, or unreasonable. So again, if I'm to my cell phone company, I'd like you not to sell my data, and they say, great, $150 extra a month, or conversely, here's the face rate, you get a $150 discount. That's clearly coercive. This is going to change over time. That's why we have flexibility right now. We permit the activity. We have some guardrails. And it's going to look very different in 10 years than it is now. Right now, first, go back to the news organizations. A lot of them depend on this advertising. I don't know what it'll look like in 10 years. If you go to the LA Times website, I'm a subscriber, it lets you opt out. And then it sort of says, but hey, if you do, we're not going to get as much money. So think about it, because that's what helps support our journalism. So there's going back to something Justin said, I think the important thing is transparency and letting consumers decide with whom they're going to share their data. And you might, Dan, say, hey, I like this little blog, or I like this, I'm going to support them. I don't mind that they have my data. And some other company might say, I don't know who they are. I don't trust them. And that's 2020. And in 2030, it might be like, oh my gosh, do you remember they used to be able to, offer discounts for that? And now we have a new regime. This is going to change. But I think the most important thing is it's incremental change, right? So we don't destroy any business models that are really good for society. If you think about the free press, it's really kind of an important thing. And we all know that newspapers, depend on advertising.
Yeah, and I think a lot of it, when we've seen it actually from the human side of the line, Alastair, a lot of this is about how can you present the amount of information for a human being to make a choice quickly enough with the attention spans and the choices you're having to make so that it's a meaningful choice. I know that's a little bit of a vague concept, but when people come to pick a service right now, and you watch it from just a user experience perspective, it's interesting. If you come to a newspaper and you want to read an article, how much are you going to read about what they're going to do with your data at the moment you want to read the article? Like, I think right now, people will read a teeny tiny amount to make that choice, but they're not going to read a paragraph of information. And unfortunately, it's kind of a complex thing. So there are some hard points in there, because, I've written I mentioned you when we've talked about this, I've written a op-ed that, that was in Newsweek around this whole concept of choice and the American principle versus the European principle. Dan's written extensively on it, but it often, to me, comes down to, as a practical matter, given what you're doing, when you run a search on Google, And if they start presenting to you, here's what's going to happen on everything. Do you really want to see that before you see the result? Because if the result comes up in anything other than a microsecond on Google, I'm a little annoyed. So there's some really weird fundamental human problems going on here on just accelerated user experience choice that is actually, and that's the hard problem that I think we're going to have to attack over time. And I get why this is a regulatory kind of framework that you're going to have to iterate on, because.
This is so exciting to me. So sorry, I apologize for interrupting, but I think it's such an interesting question, Justin. And so one of the things, I've had dozens of conversations with privacy startups this year, because now there's this law. And one thing to think about is, did we just create a privacy industry? I'm talking to a guy who's a privacy entrepreneur here, but are there multiple companies like yours that are now going to think of different ways to solve this problem for consumers? And one of the interesting conversations I had recently was with a company that's trying to figure out, how do we become your trusted proxy? We'll make those decisions for you. You tell the parameters, and then we'll interact with all these companies to kind of give them access to your data. Is there a way real time? Then another question is there a way to real time give the company enough access to my data where they can use it, but then they don't have it? So there's kind of like a temporary license to use it. And there's so many fascinating ways to think about what this is going to look like in the next 10 or 20 years, but I think we're on an arc where we're all headed to where we have more control over our data. And you're right, it can't take all of our data, figure out like who gets to see it, right? So there's got to be a solution that's easy. And I would say someone is going to make a ton of money solving that for consumers so that they protect my privacy. And I'm really excited about that, because I think you need the business versus business. If it's just the $1 trillion companies that are data mining, they win. There's got to be businesses over here that say, no, we're protecting consumers, and we're going to help consumers protect their data. And that to me is exciting. Is it going to be an app I put on my phone that protects my data? Is it going to be just iPhone is going to be like, no, we've got the market now, we've got it covered? I don't know, but it's going to be interesting.
No, I agree with you. And those points are like, even the do not sell products we have that are around, how do you capture it? How do you deal with the retargeting issues? That's an issue. When somebody wants to stop retargeting in response to do not sell, that's an actual thing that you have to figure out. That's infrastructure that, so there are a lot of these things that are coming up there. But I do think that's where the hard work is. It's on figuring out the interaction between a law and the human being that's actually achieving the end goal, while also enable people to live their lives at the speed in which they want to make decisions when they're interacting with their device. I mean, you'll see on the user experience side, anything that's microsecond delayed in actually getting what you want becomes really annoying for the consumer. And that's the thing we're often balancing, to be honest. So we're down to the last few minutes, probably a little bit over. I think maybe Dan and I can each ask you one or two questions or give you a chance to add to it. We also, on CPRA and Prop 24, there's a fair amount of, the criticism coming from the lack of a private right of action. I suspect you've heard that a lot. The amendment process has been a point of contention. Like, hey, the idea is this was developed and it can be passed and then it can be amended in a way that's really harmful. Alastair, do you want to talk about any of that or anything else on this subject? And then obviously I can pass it off to Dan too.
Yeah, I mean, the private right of action, I'm just going to leave alone. We kept it where it is, which is a private right of action with respect to negligent data breach. And that was the deal we reached with the legislature in 2018. Around the amendment process, I mean, honestly, it's we do have the people on the opposition side saying that it's wrong. Well, we have a pro bono, non-paid, independent legal analysis from one of the top constitutional experts in the state on the state constitution, a professor at Berkeley, David Carrillo, who actually totally debunked their allegations. So our amendment process works. It works well. And it works to say that a simple majority of the legislature can amend the law as long as it doesn't harm consumer privacy. You need that. This is a complicated area. As I keep on saying, this law is going to look nothing like it in 10 years as it does today. So I'm really happy, because a lot of initiatives say you need a 2/3 or a 3/4 vote in both houses. Well, that gives a lot of power to the minority party. And so I don't think that's the right construct here. But also bear in mind that today CCPA is a law that can be voted. The legislature can come back in January and just eliminate it. It's just a normal law. That's not a good way for something that I think is fundamentally a new human right. We need some protections to make sure that that this stays. And by the way, this isn't an area where there's no opposition. If you don't have this, look what 2019 shows. There are trillion-dollar companies on the other side of this that desperately want to have unfettered access to your information because that's the raw fuel for their engine. And again, I'm not trying to destroy those companies. I am trying to have regulation that makes sense, that's sensible regulation that gives us control over our information.
So I think one of the most notable things about all the development, at least for me, is the fact that you've used the referendum process, and some have criticized it, but I think one of the benefits of it is it's a chance for the people to speak. What we see is that without that process, we don't have the laws. Congress wasn't paying attention and wasn't bothering to do anything. Now there's a lot more talk in Congress to do something. The fact that what you're doing does make it clear that doing nothing and not passing regulation is an option that ultimately won't work in the long term. So the fact that doing something is, I think, pretty significant. And we'll make a statement that if this is not properly regulated, people will speak and something will happen. So it ought to be. The details, of course, are the tricky part. Privacy is such a tricky thing to regulate, and I think I appreciate what you say about how the law is going to evolve over time. I think one of the challenges I see in the framework is how does one define what is harmful to privacy or not? Ultimately, that's a judgment call that someone has to make, and it can go many different ways. In terms of what people think is what one person thinks is harmful to privacy, another person thinks is not harmful to privacy. So you will have a lot of debates and a lot of room for interpretation on that front. But I think it'll be very interesting to see how the process unfolds. And I guess my last question is, as the process unfolds, as you kind of sit now, let's say this passes, what's next? Will you continue to follow the issue? And then, what would you do as this law evolves and changes, and especially, it changes in unpredictable ways? How do you see your role as kind of shepherding the law through its evolution over the next decade?
Well, okay, so a couple of questions there. The first one around money. There is a world out there in all of our imaginations where money doesn't have such an impact in politics. But the reality is, yes, it's been expensive getting a ballot measure together. But if you think about the size of the opposition, and the amount of money that they have available to spend on lobbying in Sacramento or any other state capital, it's extraordinary, right? And so they were very successful for decades in stopping any privacy laws getting passed. So, at the end of the day, okay, I spent money to get this on the ballot, but the people will decide, and the people get to decide. So it is still a democracy. And in terms of deciding what's harmful, that's something the opposition has raised. Oh, this is going to be, who's to say what's harmful to consumer privacy? Well, a couple of points. One, the way it really works is the committees in the legislature, you have to get something out of committee before it goes to the floor in either house. And so the committee consultant will really do the analysis and sort of say, look, this is going to be deemed to be harmful. Let's say it passes out of the legislature and it goes to court. Okay, that could happen. But the reality is right now there's no protection. Right now, again, as I keep on saying, CCPA can be voted out of existence as soon as the legislature reconvenes in January. And that's no way to run something where I feel like this is a really important issue. And where businesses have actively demonstrated that that's what they not only would like to do, that's what they're trying to do. It'd be one thing if there wasn't any opposition, everybody's like, okay, this is like something that was sort of motherhood and apple pie. This is not. So businesses have shown that absent some kind of protection, they will try to destroy this. That's what we saw in 2019. And then in terms of what's next, I feel like Americans, as citizens, frankly, in the world deserve, this is a new technology. I don't know if you've seen some of those studies, but, they did surveys in like Nigeria and India. And in those countries, both those two countries, Facebook has a program where they zero rate with the carriers, where they go to a carrier and they'll say, if your consumer's using our product, don't charge them. And so the consumer ends up spending all their time on Facebook, right? And so I know they did a study and again, this is, you can read these things, but the point is the direction's not wrong. And the study I saw showed, I think 67% of Indians thought that Facebook was the internet, agreed with the statement. Well, think about the power there. It's 750 million people or something like that. So I do think that over time, humans need to have some kind of agency with respect to these platforms that have just sprung up in the last 2 decades, 3 decades. This didn't exist before. The ability of a company, a business to communicate individually to you, Dan, at a way that knows you better than you yourself, and they can do that at zero marginal cost. That's never existed before. I'm not saying there needs to be some guardrails around that. That's where I'm starting. And so what's next? I feel like the next thing is just America, is that make sure that America has some. And I think the best way to do that is make sure that California leads the way, because just like with clean air and water and catalytic converters, if California leads the way, I feel like it's the head of the arrow. The rest of the country will follow.
So, Alastair, this has been terrific. We're up way past our time, but I knew we'd get here. We have a lot more items that I'm sure would love to talk about, but I know you have a lot of work to do around Prop 24 and your normal job. Yeah. So listen, on behalf of Dan and I, thank you so much for coming. I hope you'll join us again. There's always interest really from folks on how you're thinking about things, and we'd love to have you back. Hopefully for you after the election. And there were a lot of questions that came up, so we'll just forward them to you.
No one's going to want to talk to me if we lose, so this might be my swan song here. So anyway, thank you so much, and Dan, I'll let you wrap up. We do have another episode of our privacy conversations already scheduled. It'll be on the 29th of October, and we talked with Alastair about automated decision making, and AI is always built into that. We're going to be having the founder of the company that became Alexa, and he runs a company called Prion, Igor Jablokov, who's going to be coming in to talk about privacy, automated decision making, AI, what it really means. It's going to be a phenomenal conversation with us on the 29th. But again, on my behalf, Alastair, thanks so much for joining us. A lot really awesome conversations, I would expect. Back over to you, Dan.
Yeah, thank you so much for joining us. I'd love to continue the conversation in the future. I think there'll be a lot to talk about after the election and as this continues to evolve. So thank you so much, and look forward to talking more.
Great. It's a pleasure.
Thanks, everybody.
Bye-bye.
See you soon.
Stay safe out there.